agree, we can have a sort of change in the order. So I can give the floor to Andrea Piletta for the moment, in order that we wait for Raffaele connection. And Raffaele will talk later on. So Andrea is a PhD student at the University of Turin, of Trento, sorry, but he was degreed in the University of Turin, and he is a young scholar in comparative law. And at the moment he's working at a project of a translegal word law dictionary, which, on my opinion, is quite interesting topic and quite interesting issue to study and investigate. And today is presenting for us a work on the political side of antitrust law. So please.
I have some slides to share.
Yes. Yes, you can, because I switched the command. Okay, perfect.
Let's presentation mode. Okay. I set my time. Okay. So today we are here to talk about the dark side of the law in this conference, but in this panel we will focus on competition law. So the question is there is a dark side of competition law, and I think that this can be found in the dualism between two interpretations of competition law. The one is more focused on the political side of antitrust, and it was the interpretation which characterized the origins of this subject, and then emerged after the so-called Chicago Revolution, another interpretation of competition law, more technocratic in the enforcement of this discipline, and more economically oriented, more oriented in promoting economic efficiency. And I think that this dualism is the dark side of competition law, and we will understand in the course of the presentation why. Indeed, a lot of authors have discussed the topic. Here I share some point of view, and the most interesting, I think, is the one outlined by Professor Ezraci, who saw competition law as a sponge in his famous sponge article. In his view, competition law is a sponge which absorbs all the values that are all the foundational values of our constitutional system. With the economy, which constitutes a membrane of this sponge. It's a quite interesting metaphor. However, other scholars, such as Tuke and Steinbaum, saw the dark side of competition law in the Chicago Revolution, which have, in their view, hijacked competition law from the foundational values that we referred before. So the political value of competition law, which will be rediscovered in the course of this presentation. And this political side of competition law is particularly important in the present context, which is characterized by challenges that competition law in the current state, in my view, and also in the cited author's view, the current efficiency-driven competition law cannot properly manage those challenges, which are, among others, digitalization, environmental issues, and the rising inequalities, which is quite linked with the first challenge, because of the market power exercised by tech giants and platform. Indeed, Tim Wu, who is a prominent scholar, stated that we are in a new Gilded Age, referring to the Gilded Age of the big trusts in the end of 19th century. So Standard Oil, American Tobacco. The new Standard Oil could be Google. The new American Tobacco could be Facebook. And so in order to tackle the challenges posed by the new Gilded Age, we have to know, in his view, how antitrust law managed to break up the Gilded Age big trust, so the past Gilded Age. And in order to understand this point, we have to discover which are the origins of this subject. As all knows, antitrust law is an American invention, we could say, also if some legislation against great concentration of power, public power, was enacted in England before. But the problem in the United States in the end of the 19th century was posed by the use of trust of this institute by powerful firms in order to interlock the directorates of the companies and form cartels or form great conglomerates such as the cited Standard Oil. So there in the population, a fear for bigness stem. And indeed, there is this citation from Hofstadter, which stated that bigness has come with a momentum that seemed irresistible, and no one knew when or how it could be stopped. The solution to this problem was found in the enactment of an antitrust discipline in 1890 with the enactment of the Sherman Act. However, the dark side of the Sherman Act can be found in the vagueness of the language, in the fact that the discipline, the provisions are so broad in their drafting that has to be the gaps has to be filled in by the judiciary, by the court, as stated here in this precedent by the Supreme Court. And indeed, the first interpretation came here. I cited the 1897 Trans-Missouri case by the US Supreme Court, where there is a stress on defending, on protecting the competitive process, competition seen as rivalry among firms. And indeed, the great historian of antitrust, Torelli, stated that antitrust law was aimed, with this metaphor, at controlling the highways of commerce in order to keep them free for all and everyone who wanted to run a business. Then the future developments saw the crisis of 1929, when antitrust provisions were partially suspended. But after that period, as called by Baker, a sort of political bargain emerged in order to benefit from both a sort of social protection system and the benefits of a market economy after the crisis. In substance, this political bargain means that we shall have a market economy, but we have also to set up a safety net for people who are not protected by this system. And indeed, consistently, competition law was still applied from a structural point of view, with a structural approach, as we can see from, for instance, this citation from the Justice Learned Hand opinion in the Alcoa case. But then the other dark side of competition law emerged with the Chicago Revolution, which saw among its protagonists Judge Robert Bork, Professor Aaron Director, and they pointed out that competition law should promote consumer welfare and economic efficiency. What consumer welfare is not clear nowadays, if it is consumer surplus, total surplus. For Bork, it was total surplus. And indeed, also the US Supreme Court stated that, endorsed this view, stating that the Sherman Act was enacted as a consumer welfare prescription. There is no trace before of this interpretation, but Bork was so persuasive in his aim. And indeed, the result is a lax enforcement of competition law, especially in monopolization cases. Indeed, in the United States, no monopolization cases of relevance were brought after the big Microsoft case. And also in the judiciary, we can see opinions like the one delivered by Justice Scalia in Trinco in 2004, where there is a sort of praise for monopolies because they are seen essential for giving firms the incentive to innovate. But now, after the economic crisis, after the advent of digitalization, a sort of reaction, a sort of reject is emerging, and this is the neo-Brandisian movement, which want to develop a competition law discourse focused on the political side of competition law, which is so important in our presentation today. The other important competition law regime in the world, the most transplanted together with the US one, is the European one. So it is important to understand that also the European competition law system has a sort of political matrix. And when I one point to precise is that when I talk about political side of competition law, I'm not stating that it is important that competition law shall be run by political parties with political interests, but that competition law is rooted into the policy, the political values that characterize our constitutional system. And it is particularly evident also in the European experience, because competition, there are some interpretation about the establishment of competition rules in the EU. For some authors, it is a reaction to the concentration of private power, which allowed the Nazi to take the power and take the war to World War II. Which is an example of economic power, private power shifting into political power. Other interpretations saw an influence of the US occupation forces that were concerned about the establishment of a big coal and steel organization in the EU, which seemed a sort of big cartel in this sector. And in the concentration of private power issue, it is really important the contribution from the ordoliberal school that we will analyze below. After the establishment of competition law, moreover, it is important that various political policy goals were pursued, such as, for instance, the creation of the common market. It is a clear policy goal followed by competition law, and also the protection of the competitive process. This goal was first outlined in speeches, for instance, by the first Commissioner for Competition, Hans von der Groeben, that we can see a citation here, and then also by the European Court of Justice in the famous Continental Can decision of 1973. Then the Continental Can interpretation approach was followed also in the British Airways case in 2007. And the focus was always on the protection of the competitive process, similarly to the first US approach that we saw before. And this interpretation is particularly rooted into the ordoliberal tradition. Ordoliberals, the school of the ordoliberals was created as a sort of reaction to the Nazi regime in the city of Freiburg, which was quite a calm city during the Nazi Empire. But they see the need for a strong state because they saw that the weakness of the Weimar Republic allowed the Nazi to take the power. And indeed, they, as stated by Bohm, they were interested by the issue of private power in the society. And they called for an economic constitution where competition should have played a central role in order to, as stated by Torelli for the US, to keep the highways open for everyone, to give equality of opportunity in the possibility of starting a business. And this concept is central in the social market economy system that the ordoliberals aim to establish, and which is central also in the European Union, as we saw in the Treaty on the European Union. Central is also the issue of fairness for the ordoliberals, and also in the current competition law discourse, which fairness is really highly debated as a political concept in competition law. It can be seen in Article 101, paragraph 3. It can increase the trust in the market, as stated by Ezrachi, but also by Commissioner Vestager. But it is a concept that is really political and shall inform the whole system instead of playing a role in the day-by-day enforcement activity. But it is really important in order to orient the application of competition policy. Also, the European Union suffered from the infection of the Chicago virus, as called by Tim Wu. And this is the more economic approach, really stressed in discourses, for instance, by former commissioners Monti and Kroes. Now it has been quite overcame, but the judiciary was focused also on this approach, shifted toward this approach in the Intel case, for instance, but as stated by Lianos and others, positive law still supports the view that EU competition law shall pursue multiple goals. So not only a more economic approach, not only efficiency, and also in the view of Lianos, the decision in the Intel case that seemed to have adopted the more economic approach followed by the Commission does not constitute a proof that economic efficiency and consumer welfare shall be the only goal of competition law in the European Union. So what the suggestion by Lianos is important to understand how competition law shall be. It shall be a sort of meteriotes, this Latin concept between all the interpretation given, the interpretation given, the one focused on economic and the one focused on more political issues. In particular, economy, in my view, shall not be an end in itself with efficiency, but it shall be a useful tool in order to assess cases. But we need not to forget the importance that competition law shall not be detached from our economic and constitutional system, but it shall be integrated into it, and it shall also pursue the values promoted by the European treaties, and it can be seen in environment and other issues. And this is my metaphor, similar to the sponge one of Ezrachi, which is competition law as a rock. It developed with a lot of strata, but the main view, that it shall be viewed completely as a whole, not focusing on a single part that emerged during the time. And however, this approach seems to be likely to be followed in the future, and we saw a lot of cases that we could analyze during the debate. Enforcement cases against tech giants by the Commission and by antitrust authorities, and also in the US, Biden appointed Tim Wu as a special advisor, and Lina Khan, another really Brandisian figure in the FTC. So I think that we will come to this view, to a more political view of competition law in the future. Thank you for your attention.
Thank you, Andrea. And I think that your metaphor is more picturesque than the one of the sponge. So, okay, it was just a joke. Unfortunately, I have news from Raffaele. Raffaele is trying to connecting with us, but he has many problems because he's in a sort of isolation for COVID contact in a house where the connection is not so good. So he will try again to connect later on. And in any case, without any camera, because otherwise the connection will fall again. So in the meanwhile, we can go through our session and we can have the other presentation. Our other speaker is Enter Sinet and is part of the board of Juris Diversitas since this year. And actually she's PhD in law at international law at Jean Moulin University in Lyon, and she has studied and make research experiences at Fordham University, at Harvard University, at Columbia University, and Cambridge University. So very long way and very, multi-faceted experience. She's at the moment professor of antitrust law, and she in the EHAM Lyon Business School, and her main fields of research is competition law, of course. And today she will talk with us about leniency policy and the dark side of the EU and French competition law. So please, Anne, you can unmute, and we are here to hear about your presentation. And you must unmute the microphone, probably.
Sorry. Sorry for that. Sorry. Thank you very much, because it was and I was very happy to hear Andrea. I just have to change this. I will stop my sharing just for 1 minute, because I made it in the way I don't want to make it. So I have to stop. No, it's not what yes, it works. It works. Good. So good morning, everybody, because it seems that there is no one from the US at this time of the day. And it seems that we've got no one from the East, neither. So good morning, everybody. I'm very pleased to be with you this morning. I was very pleased as well to hear Andrea Pieta Massaro on such a topic. So we've got links between what he said and what we will see now, because I will be talking about the dark side of the EU and the French competition leniency program. As you said, I'm spending most of my time for research, not for teaching, but for research on competition law. And when we are thinking, so this is my email address for the ones who wants to keep in touch with me. So if we think about cartels, we can see that cartels are really a disease, and they come from quite a long time now. If we think about what Adam Smith was already saying about this temptation that firms have to collude, so to enter into conspiracy. And usually when we are talking about conspiracy, we are talking about price fixing. So competitors are supposed to compete and not to collude, not to agree on prices or cut off production or to share the clients among them. So here we've got a question which is quite universal in time and in space. And if we have a look at the International Competition Network and its working group on cartels, we can see that they've done a significant work on this topic. And so we will be focusing on leniency today. Leniency, if we take the historical model concerning competition law, and Andrea Pieta Massaro said that a few minutes ago, come from the US, which were not, in fact, the first to design a competition law, or antitrust, if you prefer this word. But it's true that the US were the first to implement this legal system and to implement it at this scale. So the US model is not the one of the EU. The EU is an administrative model. The American one is a judicial model. And so here the commerce clause comes from the US Constitution and gives jurisdiction to the federal level for cartels when there is an impact on trade among states of the United States or with foreign nations. And so concerning cartels, so agreements on price, so price fixing, quota of production, etc., it's the exclusive jurisdiction of the US DOJ antitrust division, for the ones which are not familiar with this vocabulary in this audience. So it's the US antitrust division which is in charge of it. And for the investigation, and after it is sent for the indictment to the grand jury, and after to a district court for the judgment. And so this is the process for the public enforcement. So here, the legal basis is the Sherman Act. And so the situation was that one. We had always cartels. There was a strong implementation of Section 1 of the Sherman Act during the 20s, 30s, and 40s. And after the Second World War in the United States, we saw a decreasement in the implementation. And in the 70s, there was a will to restore a strict implementation of Section 1 for cartels. And we could see that there was many obstacles for that, because when we do have international cartels, and so in the 70s, the situation was that there was implementation of Section 1, but to national domestic cartels, not to international cartels, because it was too difficult to catch them. Why? Because evidence were abroad. So it was difficult to find direct evidence of the conspiracy. And by definition, when we've got a conspiracy, when we've got a cartel, evidence are hidden. So people try to have meetings outside the United States, even if we remember in the Lizin case that they had meetings as well on the territory of the US, as well as if we are thinking of the marine hoses case, where they had meetings in the US, in California, and they were put under arrest the top managers involved in the marine hoses case in San Francisco. But most of the time, evidence, direct evidence, are hidden, and they are outside, geographically speaking. So it's difficult, technically speaking, to catch them. So to prove the collusion, to prove the conspiracy. So because we've got so many obstacles, and Bingaman, which was at the in the 90s, the head of the antitrust division, decided to improve the system. So if we have a look at the obstacles, we could see that we've got several technical obstacles. As I said, that there was difficulties to catch the evidence. Subpoena was difficult. Protection of trade interest acts were numerous, so many countries tried to avoid those investigations and put legal obstacles to that. And there was a lack of mutual legal assistance treaties. So Anne Bingaman thought that there was a necessity to reform and to develop a tool which is called the leniency. But if we have a look at the origins of the leniency program, we can see that, keeping in mind that it's criminal law, Section 1, it's a felony, we had, in fact, the roots of the leniency program in what we can, sorry, I will just here. So we can see that the roots were in the case law of the US Supreme Court. There was a cooperation agreement which is called transactional immunity. So it recognizes a conditional power to prosecutors. And so they had the possibility to negotiate with one of the wrongdoer to obtain evidence. And this case is the Whiskey case. And it's an old case because you can see that it was 1878. After that, an assistant attorney general of the US DOJ, Antitrust Division, John Shanfield, decided to go further and to create a leniency program for corporations, so for firms, for companies. in 1978. This leniency program was quite unsuccessful because there was, the average was around one case per year, and that was it. And it was only if the company, the corporation, was denouncing its wrongdoing and the other members of the cartel before any investigation. And so in 1993, the new Assistant Attorney General and Bingaman decided to reform the system, having in mind to do exactly what the US DOJ, the prosecutors, are doing for regular crimes, and to implement it to white-collar crimes. So it's what occurred in 1993, 1994, with first a corporate leniency policy and an individual leniency policy. So to create rivalry, to work on the rivalry and the conflict of interest between the corporation and the managers, which can be sent to jail. So we don't have, so the system has been improved with administrative plus, etc., several tools. So this is a model which has been taken by the EU, but the EU legal system is different. I will be coming back to that later. If we consider the EU, the system is pretty different, because here the EU competition law is an administrative model, not criminal. It's not a judicial one, and Article 101 of the Treaty on the Functioning of the EU is not criminal law. So here we've got another model. Nevertheless, the decision was taken to integrate this tool to be more efficient. So when we are talking about the pros and cons of leniency policy, we can see that the main argument in favor, the most obvious one, is the efficiency. So there is a real political will to make the fight against international cartels more efficient, and at the same time to use the conflict of interest between the members of the cartel and to catch them and to have access to the evidence, and to reduce at the same time the costs for the competition authority. So we've got this, but we will see that this system is not perfect. So here, if we think about Article 101, we can see that there is something again in common with Section 1 of the Sherman Act, because here you can see that in the two cases, Section 1 and Article 101, there is what we call an extraterritorial effect, which means that we do have exactly the same objectives, roughly, and the same obstacles to the implementation of Section 1 of the Sherman Act and Article 101 of the Treaty on the Functioning of the EU. Why? Because the two are extraterritorial, which means that there is no condition of nationality under Section 1 of the Sherman Act and Article 101. So here we can see that what generates the jurisdiction of Article 101 is the fact that there is potential impact on interstate trade, which is the equivalent, in fact, of the Commerce Clause that we can find in the US. And we've got, of course, an anti-competitive object or an anti-competitive effect. In other words, Article 101 apply anytime two conditions are fulfilled. We've got a concerted practice, so a cartel, which have a potential impact on interstate trade on one hand, and which has as its object to distort competition or to prevent any competition. So here it means that we've got the same as well obstacles to catch evidence, and this is really the first reason leniency policy has been introduced in the EU legal system. So here, this is a definition we can find of what concerted practice is. So we've got this question of direct applicability, which means as well that this Article 101 can be implemented by the European Commission, which is and which was for quite a long time the main competition authority in charge of the implementation, but as well what we call national competition authorities. And so here we can see that the French Competition Authority can implement this Article 101. And we will see that if we consider the 16 decisions of the French competition authorities, which have been implementing the French leniency policy, we will see that all of them were based on Article 101 of the TFEU, as well as under the French rule. So it's because of this direct applicability. The sanctions that we can have, the maximum of the fine, because it's administrative law, it's not, and it's crazy criminal law, but it's administrative law, is the maximum is 10% of the annual turnover of firms. So we know that cartels are a disease, so we need a strong answer and strong tools for fighting against them. So now, what is the result of this policy? Knowing that the gravity is always taken into consideration. So here, if we have a look at the top 10 of the cases, we can see that the amount of the fines are increasing, and they are quite significant. So here, I'm taking the top 10 of fines according to cases. So we can see that the maximum is 3.8 billion euros, and it's for the trucks one. And here there was an implementation of the leniency program, and it's NAN, which is quite a significant company, which managed to obtain the total immunity. So here we can see that in all those cases, we can see that we had as well an implementation of the leniency program. So it means that here, all those cartels were international cartels, and we've seen that there was an implementation of the leniency program. So if we are thinking about the pro and cons, we can see that we've got pro because it's an efficient tool, meaning that it has been useful to catch the evidence which were kept abroad. And this is the case for the trucks, this is the case for the car glass. For the vitamin case is a landmark case not only within the EU, but as well in the US, because it's a European firm which was using the leniency program under American law as well as under European law. And it's Aventis, Rhône-Poulenc at that time. So we can see that we always had an implementation of the leniency program in all the significant cartels and for all the international cartels. So the pro is that, of course, it's efficient. But the con is that if we consider those cases, and if we have a look at the fines according to companies, we can see that we've got very heavy fines as well. It's roughly the same cases, all right, that we can see on that list. But what we can see, if we consider now each cases, is that the counts are composed of several elements, and the main one is, first of all, that it is written in the communication dealing with leniency within the EU that if you are the leader, you cannot benefit if you are the investigator. If you are, the one which was the leader, the one who forced the others to collude, you cannot obtain the immunity. But if we are a significant reduction of evidence, but if we have a look at the practice, we can see that this is something that we've got again in common between the US and the EU, is that we have a very narrow definition of being the leader, which means that in fact, in practice, you can be one which is at the origin of and which is benefiting significantly from this collusion, from this concerted practice, and obtain a significant reduction of fines, or to obtain the immunity, because we've got cases where we've got two which really initiated this cartel, and which can benefit, one of them can benefit from the immunity. So here we can see that when we are doing pro and cons, this is one of the obstacles. If we have a look at the list, in fact, of cases, and even the recent ones, because we had many cases in May, for example, and April this year, we had the railway companies, we had a huge cartel in this sector. We had another one in the financial sector with the FSA bonds. We had another one with the European government bonds trading cartel. We can see that the other negative point in leniency policy is that within the EU, as well as under the French leniency program in the EU model, we've got another negative aspect, which that we will not find this time in the US. And it's from a moral point of view and a political point of view, because in the US system, there is, to benefit from the immunity, you need to restore, and so to pay back, to pay damages to the victims, so to your clients. And there isn't this obligation to obtain the total immunity under European leniency program, neither in the in the French leniency program. So here we can see that when we have a look at the French competition authority and its implementation, it's the same pro and cons that we can find. And just to finish, because I'm sorry, I've been I will be a little bit too long. If I check, I've got just 2 minutes, so sorry.
Okay, you're okay.
I took the French example. Why? Not because I'm French, which could have been the case, but not for that. I decided to take France because among the National Competition Authority, the French Competition Authority, because it's its name for the last 10 years now, is the most active in the European competition network. So for the ones who are not familiar with that, the European competition network was set up in 2003 and is composed of the national competition authorities of all the member states plus the European Commission. And the French competition authority is the most active. And when I'm saying so, I mean by the most active that it's the National Competition Authority, which is investigating and making decisions based on Article 101 and 102. So it's the most active because if we consider the number of its investigations and decisions based on Article 101 and Article 102 of the TFEU, it's the case. So the French Competition Authority, since those last 10 years, pronounced fines around 5 billion euros in this sector, and pronounced 98 decisions on anti-competitive practices based on Article 101 and Article 102. And it means that there was around 450 firms, undertakings, and trade associations which were concerned. But if we have a look at the number of sector inquiries, we had 12 sectors inquiries developed by the French Competition Authority. And if we have a look at the leniency policy, the idea and the way it has been developed is really to fight more efficiently, and this way to save time to do more sector inquiries. And it has been the case. So this is a positive aspect as well of the leniency policy. It gives more time for the competition authority to investigate on interesting sectors like the digital sector, to make the link with what the former speaker did. So here it's something when we are doing pro and cons, it's the case. And the French Competition Authority has managed to catch many cartels. So 16 decisions has been made under Article 101, as well as under the French Commercial Code, this article, which is the equivalent of Article 101 for the domestic market. And we've got an integration of the leniency policy within our legislation, because we can find the leniency program in the French Commercial Code. And it's one tool among others, because we've got, as well as at the EU level, 3 negotiated procedures, and one of them is the leniency policy. It's quite a successful tool, and we've got the total immunity, or we've got possibilities of a reduction of fines depending on the quality of the evidence which are provided by the wrongdoers, and the quality of the cooperation and of the good faith during the procedure, during the investigation. So it's always conditional, nothing new on that. If we consider this French leniency policy, we can see that we had 16, so sorry, because it's in French, because it's a work in progress. And so we've got 16 decisions which have been based under Article 101 and French competition law. So you can see that because of the direct effect of Article 101, and because the French market was a significant part of the market in question. What is interesting in some of those cases, if we take this case, sandwiches, it's a recent case of March this year, we had an implementation as well of what we call the leniency plus. So here we can see that one of the member benefited from a significant reduction of fines because it decided to reveal another aspect, another cartel. And after another member was applying for the total immunity. We had another huge cartel, which was in the salami and those markets. And we had, you can see, other cartels which are on compots, Uber, things for the floor, transportation. Here it was on yogurts, etc. Here it was another case in 1914 for paper walls, for cleaning your house, chemical products, it was in B2B, farine, it was in B2B, products for washing machine, B2C market. So we've got many cases, somewhere in B2B, somewhere in B2C. So to conclude, we can see that here, when we are doing pro and cons, we can see that the huge problem with the EU and the French leniency program is that concerning the victims, concerning consumers, the final users, as well as clients in B2B, the main difficulty, and above all for consumers, is that there is no obligation to redress for the applicant to the leniency policy. So the one benefiting from the immunity do not have to obtain the leniency to give damages to the victims of this cartel, so to this concerted practice. And I think that it's the major difference with the US system, but it's as well, politically speaking and ethically speaking, it's really a significant problem with the leniency policy. So sorry, I've been a little bit too long.
Okay, thank you, Anne, for this very complete and very interesting presentation. I am trying to manage also with our third speaker, and I think that now is inside our meeting. So Raffaele, are you able to just switch on the microphone and make the presentation? Because I see that you also share the text of your presentation in the chat, so we can read the presentation, of course. Do you think you can switch only the microphone, or we can give space to the question and answer? Okay. Okay, no. Is writing in the chat that he cannot speak properly because the connection is not so so adequate. So I think that we can have more space for question, answers, or for any insight. And you want to say something, but I cannot hear you if you don't unmute the microphone.
Can you hear me now?
Yes.
Yeah, so sorry. No, I was kidding, because I was saying that I was too long, but in fact, I can be longer.
Yes, and I didn't interrupt you just because I realized that Raffaele had many problems. And no. I want to thank you both, because the presentation were very interesting, and I think there are many issues on the table. So first of all, I want to give space to, if there are any, to some question by the other participant, or any comment or any insight. Okay. In the meanwhile, that someone is getting the hand up, I just have a first question for Andrea. Andrea, you said, and I agree with you, that in a certain way, the dark side of the Sherman Act was its vagueness and the legislation technique to be very general. But probably, don't you think that this way to build general rules and principle was exactly the aim of the Sherman Act? I mean, it was just the goal was to start in a certain way to discipline an area of law, a subject matter which was virgin. So the idea was to give general principles that could be also by a jurisprudential way and case by case lawmaking of judges, a sort of, a sort of legal framework. But the idea that the judge can intervene after is also a way to adequate, to make the legal rule, the legislative rule, sorry, in a certain way through the interpretation process, through the hermeneutic process, just actual and adequate for economic and social change, because this is an area where economic and social change has a lot of weight.
Yes, of course, it is true, and maybe during the presentation, I had to make a compressed image of the whole things, and some points may be dark for the audience. Yes, of course, I think that this is a precise intent of the legislator who enacted the Sherman Act, and this is a main characteristic of competition law, but both in the US and also in the EU, because in the EU also we have broad provisions. We have the guidelines from the competition authorities, the Commission on the application of competition rules, but as also stressed in a recent paper by Sir Peter Roth, also in the EU, competition law is one of the examples of a common law approach also in the European Union. This is a very interesting point. And of course, this broad language, it is important to adequate competition law. I think that it is a positive and a negative aspect of the discipline, because the discipline can be applied and can be adapted to the various times and the social and economic conditions at stake. But on the dark side that I was referring to is the fact that as stated by Stuke and Steinbaum, that competition law can be hijacked due to this broad language and this broad interpretation, because in my view, but I'm quite I'm quite
I agree, I was just provocative.
I'm quite a Brandisian thinker, so I have Brandisian positions, so I really think that the Chicago Revolution is something that is quite not in line with the legislative intent of the drafters. And the important point is, and this is the really dark side. I'm trying to be clear for the audience. The fact that this broad language allowed in the future respect to the Senator Sherman, Senator Hoare, and others, to give these provisions a completely different content in respect of what they imagined in 1890. I think this is the dark side characterized by due to the broad language of the Sherman Act.
Okay, thank you.
May I add something? Yeah, because
yes, I think yeah.
I was very interested in your presentation, Andrea, Sarah. And there is a huge debate as well in France on that. And I think it could be very good. I will send you the name of an associate professor in Paris at the University Paris-Nanterre, which published an article on the end of the order liberalism, right? On order liberalism. I think that it could be of some interest and a good connection between the two of you. And to comment on your question, Alessandra, to Andrea, it's true that this question of vagueness of the language, I agree with what has been said. And I want to say as well that it's interesting in a conference, Juris Diversitas, because if we think about the legal history of the US, we do remember that when they decided to choose the common law system, there were a country which was mixing the common law system and the civil law system, and so the civil law tradition. And if we think about the US Constitution, it's really based on the civil law tradition. And if we have a look at the Sherman Act, it's true that it has been done on purpose, this way of writing, and it comes directly from this tradition. So that's the reason we've got this debate. So it's very nice that you started, Alessandra, by this question.
It's media press, you know.
So I was,
and Andrea was making in my mind the idea of the intention of the legislative power at the moment. So maybe the intention was different, but if judges are now able to interpret in an evolutive way, in a way which is adequate to the changes, I think that general rules and general principles as a value that has to be preserved because they are able to give in a certain way, to give goals, to give policy goals, and sometimes better and in a wider way than statutory rules, which are really specific, but sometimes lose the spirit of the law itself. Okay, and goes, yes.
If there is question to the floor, I don't want to be too long.
Yes.
But that was very interesting as well, Andrea, when you were talking about the position of our commissioner, Margaret Vestager, and if we compare our position to the one of, for example, Neelie Cross in 2004 until 2010, which was very different and which was much more pro-Chicago school. So we can see that taking a large snapshot, a large picture, we can see that the evolution of the European Commission is going in that direction. And we can as well think about what Margaret Vestager did by using the Article 107, so the state heads to fight against those GAFAMs. So here we can see that you choose a very interesting topic, and which is very dynamic, and we've seen that your topic is really of full actuality, because if we are thinking about the last decision which has been pronounced, you are really on something which is highly significant, economically speaking, politically speaking, and of course legally speaking. So very good choice for your PhD. So we are encouraging you. That's nice.
So,
Andrea, do you want to say something?
I think that what Anne told is really interesting, and I think it is. I want to only to say that the policy shift from commissioners Mario Monti before, Nelly Kroes then, and now Margrethe Vestager is significant. And I think that Vestager's approach is the right one. And although I qualified my positions are quite Brandisian, I'm not totally a disruptor, and I think that Commissioner Vestager is finding the right way, because she is merging the political side of competition, for instance, in the fight against the big tech, in the evolution of competition law in the green sector, so making competition law greener. But not forgetting, in the same time, not forgetting the good part of the economic thinking applied by the Chicago reasoning, because what is, I think, commendable from Bork is stating that competition law shall be enforced also by means of pursuing an economic analysis during the assessment of the cases. I think this is commendable, but it shall not be an end. I think it is a means, not an end in itself, to pursue only efficiency and not to think about the social implication it has. And I think that this is evident, and the policy shift also adopted by the Commission is, and also by the new Biden administration, is based on present conditions, which saw a real explosion of market power by certain firms, and this is a good thing from a certain side, but also statistics and economic research found that this is a problem for wealth and income inequality, and that we have to address. There is an interesting paper from Ezrachi and others from the center they established in Oxford about competition law and inequalities. And it shows precisely that excessive market power is a problem for income inequality. So this policy shift, I think, is essential, but also for maintaining the trust in the market from small firms, small firms, but also the consumers, because it is interesting as a conclusion that the subtitle of Ezrachi and Stuke last book, Competition Overdose, and the subtitle is how the competition mythology transformed the consumers from citizen kings to market, to be at the service of the market. I think this is a point we have to reflect on.
Thank you, Andrea. I think there is also an hands up by Gian Matteo Sabatino. Gian Matteo, do you want to
Yes,
unmute? Yes.
Good morning. First of all, I apologize for the video, but I am experiencing some connection problems as well. So I do not want to overload my already poor connection. So I hope that you can forgive me. And actually, I wanted to ask a broad question to both of the. I am talking from the perspective of a Chinese law scholar. And well, the model of competition in China, but not only in China, also in other parts of Asia, and I think about India, for example. In these models, the idea of a political character, a political nature of the antitrust law has well been emphasized more and more, especially in the past few decades. And well, with regard to China, I think just by reading the news, we can realize how the political connection affect the development of antitrust law and regulation. And I think that from a comparative law perspective, this experience, this phenomenon raises the issue of the confrontation and competition between competition law models. And for example, I was really interested in the decision, I think it was from 2 years ago, I'm not sure, the Alstom-Siemens decision concerning, well, basically the concentration, which was ultimately rejected by the European Commission, and where, well, the enterprises also raised the point of creating a European champion against Chinese competitors. And therefore, I would like to ask, in this context, so the evolution of the political side of antitrust law, which can be in the near future, for example, with the new Biden administration or with the new developments at the level of the European law, what may be the influence of the considerations regarding the pressure from foreign competitors, and especially from Chinese competitors, and from the Chinese political model of competition law in the development of Western competition law in the US or in the European Union. And thank you very much.
Andrea, do you want to start, and after I finish?
As you like. The question is particularly interesting, and I think goes to the heart of the problem. The regulatory competition aspect is one of the most important when thinking about the regulation of competition, especially in the field of mergers that Gian Matteo mentioned. I think that we have to make a distinction between the political side, as I intend this, and as was addressed in the presentation, which is the political side from the European and American perspective, which is using other words, a policy side more than a political side. As I mentioned during the presentation, our political side is rooting a competition law into our broader tradition of values and principles. And these other political interpretation of competition law are more centered on industrial policy, and I think this is the case of China and other countries. I think that competition law has a role, has something in common, of course, with industrial policy, but I also think that it is important to take these two fields separate in a certain, at a certain extent, because I know I heard about the debate after the Alstom Siemens decision, and I heard I read an interesting comment by Tommaso Valletti, who is really famous and was the chief economist at the European Commission, DG Comp, and stated that, and I agree with him, that we have to be really careful when thinking about national champion, European champion, because the creation of champions could undermine the very competitive process that we have referred to during the presentation. And indeed, I think that the Commission was compliant with EU competition law principles and with these, into brackets, ordoliberal view of preserving competition as such. Because if you think of the decision in Alstom Siemens, the merger was blocked for a presumed excess of market power in the railway signals market, which we can say it is something fringe in respect of such a merger and in respect of creating a champion that will win national, international contracts vis-a-vis the Chinese and other countries' competition. It is a really interesting topic, and I think that there is not a right answer. I think, and this is as a conclusion, as a concluding remarks, very interesting to raise this point in this conference, a different view, a different culture of what is the role of the state into the economy and what is the role that competition law has to play. But I think that in our context, we have to intend political influence as policy and principles influence, not as governmental influence. And in this direction, Directive 1/2019, the SCN Directive Plus, I think is telling, because it aims to strengthen the independence of competition authorities from the political power.
Thank you very much.
Your point?
So thank you for this question, because it comes back to first think that we can add to what Andrea said at the beginning, which is that, first of all, EU competition law is a common policy, and it's a common policy which is not above the others, all right? So it has to match with the others, like agricultural policy, etc. At the same time, as you mentioned it, we've got a significant problem within the EU, and the Alstom and Siemens case was illustrating that, which is that there isn't EU industrial common policy. And what is funny, but not that funny for our economy, is that the same countries which were criticizing the European competition policy are the same which were reluctant to set up a real industrial common policy within the EU. So we've got here a real political problem within the EU, which is a crazy federal system, which is not yet achieved. And this is true that we've got here a construction which is an ongoing process, which is not finished. And this is true that we've got here a real problem because we've got this lack of a common industrial policy, and above all in a global world. So if we compare, and in your question, there is several degrees with China, where we can see that most of the Chinese competitors to our industries are companies which are financed by the Chinese state. So here we've got a competition which is distorted by thanks to that. But this is something which is a reality. We can just see that you're right. We've got competition between states, and so a kind of competition between competition authorities worldwide. But nevertheless, what we can see is that we do have some differences. So when you were mentioning India, we've got significant differences between China and India concerning their competition policy and their competition authorities. Because if we consider India, India has a commission, a competition in charge, a commission in charge of competition law, which is completely independent from the power and which is able to fight with the government. And so it's a real independent competition authority for the moment. So far, so good. All right. And the court, the Supreme Court of India, is following the commission, the position of the commission. So comparing and contrasting the position in India and in China is quite interesting because the situation is very different. And we've seen in China with the reform, with only now one competition authority, with a kind of decentralization, nevertheless. Of course, when we think about the structure of China, we can see that the Chinese competition authority is not really independent, as it is the case for the commission in India. What we can see as well, if we have a look at the different cases which have been decided in China, we can see that nevertheless, concerning merger control, we can see that it has been pretty fair. If we have a look at the Coca-Cola case, where for the first time the Chinese MOFCOM, because it was a MOFCOM at that time, refused, so said no to the acquisition by Coca-Cola of this Chinese firm. It was quite fair. The analysis of this decision shows that it was pretty fair. So because there was, we will have seen in the close future a real reinforcement of Coca-Cola position within the Chinese market, on the Chinese market. And if we are thinking about the other case, I'm trying to it was Mark's case, you know, this acquisition in sea transportation. The EU said yes to this case. They notified as well within the US, and the US said, all right, green light, and the Chinese said no way. And if we have a look at this case as well, this implementation was right of the Chinese anti-monopoly law, because it was true that the market, which will have been really jeopardized and significantly, was the Asian market. So if we have a look at real cases, all right, we can see for merger control, we can see that there is no distortion in the implementation of that legislation. So that's part of what I wanted to say. And I will just finish, if I've got 2 minutes, may I? Thank you, Alessandra. On Andrea, when Andrea was comparing and contrasting from an historical point of view, when he was mentioning the situation after the Second World War and nowadays, he was right in I think it wasn't just for to have an historical perspective. It's completely true what I mean, that it's really significant to do so, because what occurred after the Second World War, it wasn't only the Nazi regime. We have seen, for example, firms like Ford. Ford was playing against the interests of the Allies because of Ford, because of the CEO of Ford, which was pro-Nazi. But we've seen firms in the US which were not pro-Nazi. I mean that it wasn't ideological, which played against the interest of the Allies because it was in their economic interest. So that was just to make money. So they were using the Spanish territory to dynamize their benefit, and to do that against the interest of the Allies was not the objective, but was a result. So here, all the collusion that we've seen during the Second World War by American firms were showing that we may have some firms which have such an economic power that their economic power is much bigger than the one of states. So here, the parallel, which has been done by Andrea is perfectly right. We've got exactly the same situation nowadays, and it's getting worse nowadays. And we can see that this jeopardizes citizens, and this is really a threat. And so states have to cooperate using competition law to regulate really the market. So I agree with your approach.
Okay.
Maybe I can say only one thing about the discourse made by Anne. There is an interesting quotation from Commissioner Vestager. She stated that the big tech giants are becoming the center of large empires, and this is quite significant. Also, because of the person who made this statement. Only this quotation I wanted to say.
You're right. There is a huge, a huge debate on this, and I think there are also instances of sovereignty by states, which are not only because of sovereignty itself, but just also because of the interests which are behind the excuse of sovereignty, I would say. So thank you very much for the inspiring presentation and for the dialectic debate, which was very interesting on my opinion. And maybe we would need 1 hour more, but unfortunately we don't have it. So I again thank you all, and thank you all the participants, all the audience, and see you in the next session probably. Okay, bye. Thank you.
Thank you. Bye.
Thank you. Let's keep in touch.
Yeah.
Thank you very much. Bye-bye.